Law of trust, charitable trust. This is one of the main topics in the law of trust. Law of trust, we have studied express trust, implied trust, resulting trust, constructive trust. Those are on the basis of creation. Now today we are seeing the charitable trust, that is on the basis of purpose or object. Charitable trust for the benefit of public or section of the public. For the benefit of public or section of the public. Then in a charitable trust, beneficiaries are public or general public or section of general public. The definition that we have seen in section 3 for the term of expression beneficiary. Beneficiaries means a person or defined and definitely ascertainable class of persons for whose benefit the trust is created. Then the meaning here, is it possible to identify the public, because it is for the benefit of public. Charitable trust is for the benefit of public or section of the public. Can we identify? Or even can you identify the group or the class of persons? The public, general public. Then we will see the section 3 umbrella clause. The umbrella clause provides that in this ordinance, unless the context or subject matter otherwise implies, that means, generally speaking, the term of expression defined in the interpretation clause that will apply the whole statute. But if you say that context requires otherwise or subject matter requires otherwise, that means there are circumstances, there are some sections. Maybe the definition whatever given in this one may be modified. Therefore, there is no contradiction, really speaking, that beneficiaries may be a person defined very well, or sometime in the case of section 99 charitable trust, it may be a general public. You can't identify by person. Then that's a benefit. Then when you see the section 6, beneficiary should be certain, that we have studied. Now here, when you come to the charitable trust, that's not mandatory requirement. It is flexible. Even you are unable to identify the beneficiary, that's not the big issue because of section 3 umbrella clause. Now we will move on to the object or purpose. That I have already explained, but here the object of purpose must be clear. That's always there. Even section 6 provides that the same thing. Object or the purpose must be clear or certain. And something like night versus night. In the case of night versus night, the same decision given. Purpose should be clear. If author of the trust leave the discretion to the trustee to apply a fund to a charitable or non-charitable purpose at his option, then there is no charitable trust. Because the author of the trust must decide whether it is for charity or not. If it is for charity, then it is valid. If it is not finally given, the discretion given to the trustee to decide whether it is charitable trust or not, then there is no trust. If the gift for charity, the wide discretion given to the trustee, that's fine. That is acceptable. Then we will move on perpetuity. Section 110 of the trust ordinance provides some limitation and restriction to the perpetuity rule. But section 110 subsection 5 of the trust ordinance provides that the rule against perpetuity does not bind charitable trust. Like a legal person here, it goes on without any limitation, time period. But in the private trust, there are limitations that we have seen in section when we study this express trust. Now we will move on de facto trust. When we study section 5, we have seen subject to the provisions of 107. There is something different. Then when we study section 6, reasonable certainty, we have seen subject to the provisions of section 5 and 107. Then what is this 107? That we will see now. In dealing with any property alleged to be charitable trust, then the first thing is alleged to be subject to a charitable, not private trust. Then this is one first condition, it should be charitable trust. The court shall not debar from exercising any of its powers by absence of exercising any of the powers by absence of evidence of formal constitution of trust. What we have seen when you create a trust, the formal constitution is there. That's section 5 and section 6. Then court has the power to declare even the trust is not in writing, even the reasonable certainties are not clear or not certain, the court has the power to declare that there is a trust. That should be in relation to the charitable trust, not the private trust. Then we will see section 99. Section 99 very clearly defines. First of all, I would like to say it defines, because the expression charitable trust includes, not means, that you must keep in your mind. Includes in the sense it is not exhaustive definition. You can bring something else also into this definition. That's the idea. Includes any trust for the benefit of public or section of the public within Sri Lanka or outside Sri Lanka for any of the following categories. That's very important. Following categories. For the relief of poverty, the advancement of education or knowledge, advancement of religion and maintenance of religious rites and practices. Finally, any other purpose beneficial or of interest to mankind not falling within the preceding categories. That is open. Whatever beneficial to the mankind that may be brought under this section. Brought under this. Then that's why includes. Then you can bring some other matters also. Then when you say this is for charitable trust, first thing is it should be for the benefit of public or section of the public. The second thing, it should fall under one of the categories given under section 99 of the trust ordinance. Then only you can say there's a charitable trust. Then we will see the benefit of public or section of the public. That is also one of the main issue in this one. The trust is to be a charitable trust, then it should satisfy two requirements. There are criteria to fulfill to be a charitable trust. The first one is that should be for the benefit of public or section of the public. Second thing is it should be for the charity. Charity, what is the charity now? What we have seen in section 99 of the trust ordinance. A trust or charitable trust is for the purpose of public nature. That's not the private nature. The beneficiaries of the trust, which constitute general public as distinguished from private individual, is charitable trust. Then if there is a charity, trust created for charity, but the beneficiaries are private individuals, then it is a private trust. The beneficiaries are general public or section of general public, that is charitable trust. That's a big difference. We must keep it in your mind, whether it is for public or whether it is a private individuals.